Hi everyone, this is Ashley Sloat with Aurora Consulting. We will be talking about Intellectual Property 101 today, and this is part 1, in which we will discuss copyright, trademarks, and trade secret. Please join us for part 2 to discuss patents. As you know, my name is Ashley Sloat, and I've been in the advanced sciences or in the patent space since about 2008-2009. I am now president of Aurora Consulting. We are a patent strategy firm geared towards early stage companies. We help these early stage companies formulate their patent strategy, draft applications, prosecute applications, do searching, help match their patent strategy to their business strategy, help them maintain their portfolio long term, and adapt their strategy over time. If you'd like more information about us, please visit us at aurorapatents.com. So today we are talking about intellectual property, and I think when somebody thinks of property, they think of fences and land. That's probably the most common type of property that is owned. It's a piece of property, for example, your land, in which you put a fence around. And you may have different types of fences, right? You may have a picket fence around your house or an electric fence around livestock that are on a grazing field. And intellectual property is no different. We have different types of fences depending on what type of item we are protecting, what type of land we are protecting. So what is intellectual property? It is an idea, invention, or process that derives from the work of the mind or intellect, also an application, right, or registration relating to this. So let's unpack this definition a little more. So it's an idea, invention, or process. So what is an idea, invention, or process? It may be the design of a handbag, a device for listening to music, for example, a medical device, or an IoT device, which is one of the areas in which Aurora specializes in. It may be a composition of matter, or a chemical, or a drug. It may be a literary work, a process, a manufacturing method, a logo, a slogan, software, or even a secret. And intellectual property also pertains to an application, right, or registration relating to an idea, invention, or process. And these applications, rights, and registrations are copyrights, trademarks, and trade secrets. And then we will cover patents in part 2. So let's dive into each type of application, right, or registration. So we'll first talk about copyright. What is a copyright? It protects original works of authorship. So examples may include literature, for example, the beloved Cat in the Hat from our childhood, a drama, for example, the recently famous Hamilton play, music, including words, sound recordings, for example, Hello by Adele, art, for example, a painting, architectural works, software, among others. So what does copyright prevent? It prevents others from reproducing the work in copies, so that means maybe photocopying a book or copying a script of a play, preparing derivative works, so maybe you change a few words here and there in a book, or you change a few lines in a play, but largely keep it the same. That's a derivative work that is probably still not attributable to you. It's still from the previous author. Distributing copies of the work to the public, so that means you've made copies and then you're now selling it or giving it to the public. You cannot perform the work publicly unless you receive permission. For example, if you wanted to perform Hamilton, you would need to receive permission, or you cannot display the work. So if you have a painting, you cannot display it publicly, again, unless you receive permission. You can do any of these things if you receive permission. If you do not have permission from the author or authors, you cannot do any of these. In order to register a copyright, it's actually very easy. You can probably do this by yourself. It's a very cheap fee as well. You have to mark the work with a C in a circle, date it, and include the name of the authors. Submit 2 copies of the work to the Copyright Office within 5 years of publication, and the protection lasts for the life of the author plus 70 years. And again, to enforce your work, you would have to find somebody else doing one of the things I mentioned on the other slide. There's the Copyright Office or the Patent and Trademark Office does not monitor your rights. That is your responsibility. For additional information about copyrights, you can visit the Copyright Office or copyright.gov. So there was a brief intro into copyright. Trademark. What is a trademark? It's a unique word, slogan, stylization of word or slogan, design, symbol, sound, color, smell, or combination associated with goods. It identifies the source of the goods. For example, did you get it from Walmart or Whole Foods? Distinguishes your goods from goods sold by another party. Did you get your beverage from Coca-Cola or Pepsi? And the protection lasts 10 years and it's renewable every 10th year. So here are some iconic examples of trademarks. You have the Apple symbol, the Pepsi name and logo, the McDonald's golden arches and name, the Nike name and swoosh, the GE symbol and the slogan Imagination at Work, the Chevrolet symbol and the Chevrolet word. And again, as you kind of look at these, you might realize that there are trademarks everywhere, in commercials, on billboards, on vehicles, on articles, you name it. So what are the benefits of trademarking? It gives you the legal presumption of ownership. That means that if someone brought suit against you and you had a registered mark, the court would say that you likely have ownership, but now the other party must now prove that they in fact actually had ownership and you did not. It's the exclusive right to use the mark across the U.S. and its territories. If you would like to use the mark in other countries, through the registration process, you would have to register it in that country. Also, public notice of ownership of the mark. Once you receive that registration, it is published by the U.S. Patent and Trademark Office, so put the public on notice that says that you own this particular mark. The mark is listed in the USPTO's database, which means that when attorneys search the database for similar marks to the type that you're trying to register, any similar marks will be found because it's in the database. You can also record the mark with the U.S. Customs and Border Protection. So if you have a good that has your mark on it, and there is a similar good with a similar mark trying to come into the United States, the Customs and Border Protection can stop that mark at the border potentially. You have the right to bring legal action, and you can use the R in a circle, and if it's not federally registered, you use the capital TM. So how do you choose a good trademark? You want to have a reduced likelihood of confusion between your mark and others, and you want to have a really strong mark. So let's go through these in turn. So how do you have a reduced likelihood of confusion? Your mark cannot be similar to other marks, and it cannot be protecting similar goods and services. So here's an example of that. For example, if your mark is X-Seed, X-SEED, and you're selling seeds for planting, and a registered mark is X-Seed, EXCEED, selling live plants, your X-Seed mark is likely not going to be registrable because it sounds very similar to an existing mark, and it's selling very similar goods and services. Now, if your X-SEED, X-Seed, we're selling photography or selling vehicles or anything that's very unrelated to plants, it would likely be registrable then because it's they have maybe a similar mark, but it's very unrelated goods and services. So a consumer looking for live plants won't necessarily come across yours because yours designates photos or vehicles, for example. And you may see that the words are different, they look different, but if they could seemingly be pronounced in a similar way, they're likely not going to be registrable, especially if they have similar goods and services. And you also want to choose a very strong mark. And so we have a sliding scale here of mark strength from generic to descriptive to suggestive to fanciful or arbitrary. So let's look at an example of each of these. So generic would be using milk as a trademark to describe a dairy-based beverage, or ball to describe a baseball. These are likely not going to be registrable because they're super generic and anybody could use these words to describe these types of goods. Descriptive is slightly better. For instance, ultimate grill to describe a grill, or creamy to describe ice cream. Again, almost anybody could use these words to describe these goods, so it's likely not going to be registrable. You could do better. Suggestive, quick and neat to describe ready-made pie crusts, or glance a day to describe calendars. Again, it's decent. You have an idea of what it's describing, but maybe not quite, and so this is much more likely to be registrable than generic or descriptive. And lastly, the best category is fanciful or arbitrary. So for example, Cisco to describe IT and networking services, Microsoft to describe computer-related services and goods, Pepsi to describe a carbonated beverage, or Apple to describe computer-related goods and services. So as an example of arbitrary, you think of an apple, you think of fruit, you don't think of computer-related goods and services. Or Pepsi is somewhat of a fanciful name. It's basically a made-up word to describe a carbonated beverage. So these are really great examples of fanciful and arbitrary trademarks. So again, trademarks, it has to have a reduced likelihood of confusion, and it has to be a strong mark, or at least relatively strong. But don't confuse trademarks with domain names and business names. If you get a web address, for example, using internet.net, which has a whole list of domain names, that does not mean you have a trademark. You could try to register your domain name as a trademark. For example, I believe Amazon does have www.amazon.com as a trademark. But just getting a web address does not mean that you have a trademark. And then there's also a business name. If you've secured a business name through your Secretary of State, that does not mean you have a trademark. You could also try to trademark your business name and its appearance, but just getting that business name with your Secretary of State does not in of itself mean that you have a trademark. If you need additional information about trademarks, please contact the Trademark Assistance Center or go to uspto.gov. So we've talked about copyrights, trademarks, and now we will discuss trade secrets. So what is a trade secret? It's any confidential business information which provides an enterprise a competitive edge. So again, that competitive edge is key. It can't just be any random information. It has to be something that really provides an edge to your business or organization. So examples are sales methods, distribution methods, consumer profiles, advertising strategies, lists of suppliers and clients, manufacturing processes, recipes, or compositions. And one of probably the most iconic or well-known trade secrets is the Coca-Cola trade secret. Nobody knows the recipe. It's kept under lock and key in several different ways. And they've taken extreme measures to make sure that it has kept secret. So what are the protections that a trade secret provides? Trade secret really only protects you from misappropriation of that trade secret, which means that if there is unauthorized disclosure or obtainment of the secret by improper means. So for instance, maybe your employee tells somebody that they're not supposed to, a competitor, a friend, a news outlet, that's unauthorized disclosure. Or if they obtain the trade secret by some improper means, maybe if somebody breaks into a phone or into your building and steals the trade secret, that would be obtainment of this trade secret by improper means. So this is how trade secrets are protected. It's really you only see that protection through misappropriation. Otherwise, the protections that you receive are on you, where you have to do things to make sure you are trying to keep it secret. They're generally protected under state law, although there has been some federal push to have some kind of federal trade secret protection. It requires the enterprise to take steps to keep the information secret, and I'll go through some examples of that. And then the protection lasts indefinitely as long as it is kept secret. So how do you keep a trade secret secret? Require confidentiality agreements between your employees and you, your clients and you, customers, basically anybody who might be part of the process. Control access to information. Only allow those who need to know the information to access the information. Use confidential designations. Just like the U.S. government uses top secret on certain items, you should also be using confidential or trade secret on certain items. Use embedded codes to trace copies so that you can make sure that nobody is copying your items. Conduct ongoing employee training. Have a monthly trade secret seminar where you talk and remind employees about what trade secrets are and what misappropriation means and what are the how are they punished if they are found misappropriating a trade secret. Restrict downloading of company information. So only allow downloading when absolutely necessary. Retain the right to wipe drives and external devices if you find that they're misappropriating or if they're leaving the company. Prohibit use of personal accounts. Only allow them to use their company accounts for company information. Require the use of passcodes on devices. Express the company policy regarding cloud and external device storage methods. If you have a local server, make sure they're always using that server. If you use Dropbox or something else, make sure they're using the appropriate storage means and communication means. And perform exit interviews to review confidentiality agreement and ensure all company information is retained or returned to you. So that means making sure that your employee understands what he or she signed in the beginning, that they wouldn't share information, and that they don't take trade secrets with them to their next employment opportunity, and that they return all items to you. So again, we've talked about copyright, trademark, and trade secret in brief today. Copyright protects original artistic or literary work. Trademarks protect the brand for goods and services, and trade secrets protect inventions that are kept secret by a company. The length of IP protection is 70 years plus the life of the author. For copyright, trademark is 10 years and it's renewable after every 10th year. And trade secret, it's indefinite as long as you keep it a secret and take those measures to keep it secret. These are the IP governing bodies. So the Copyright Office is in the Library of Congress. The trade secret is controlled state by state largely, and the United States Patent and Trademark Office has offices located in California, Colorado, Michigan, Texas, and headquarters in Virginia. And that will bring us to part 2 in the next segment, so please do join us.